All right, everyone. Hello and welcome to this very special and initial session of the Fast Case Leaders in Law series, sponsored by Fast Case and our in-house publishing arm of Fast Case, Full Court Press. I want to welcome everyone to the session. We have a fully packed room today. So what we're going to do with this new Leader in Law series is we're going to have monthly conversations with lawyers and legal scholars who are creating lasting impact at the intersection of law and social justice. My name is Ken. I am your West Coast reference attorney. I am joined by our head librarian and manager of outreach, Erin Page, who will help me moderate this session. Now, our special guests today are Mitchell Katine and Paul Smith, the two attorneys at the forefront of the Lawrence v. Texas Supreme Court case. Now, before I turn it over to these fine gentlemen, let's start with our traditional housekeeping. To avoid background noise, everyone has been muted. If you have questions, please post them in the questions box, and we will get to as many as possible during the live session. Unanswered questions will be replied to via email following the session. Additionally, this webinar is not available for CLE credit, with the lone exception being for the Texas Bar Association. If you attend the entire session, Texas Bar members, you will receive 90 minutes of CLE credits. Erin will provide you with the course number at the end of the session. Otherwise, for everyone else, while you will not receive CLE credit, I promise you will learn a lot and otherwise have a fabulous time. Now, finally, slides and a recording of the session will be sent out via email at the email you provided at the time of registration. There is no need to independently request a copy of either. Now, with housekeeping covered, I'm going to turn it over to Erin, Mitchell, and Paul to start a conversation of why we are having this webinar and to allow Mitchell and Paul to receive proper introductions. Take it away, Erin.
Hello, everyone. Thank you for that wonderful introduction, Ken. Today's webinar is a fantastic opportunity for everyone who's attending and for everyone who will be able to see the recording later. Of course, date-wise, we are looking at a fantastic opportunity to celebrate Pride and the LGBTQ movement and all of the accomplishments that have happened as a part of that movement, both in spreading freedom of expression, freedom of self, and all of the other rights that are so intrinsic to our society. This is a great opportunity as well to celebrate the jurisprudence that has come about as a result of Lawrence v. Texas. Today, or this month, we are celebrating the 17th anniversary of this landmark decision, which kicked off a huge number of subsequent decisions that have gone very far in spreading this particular area of privacy and area of jurisprudence to other situations, many of which we'll be discussing today towards the end of today's presentation. Just again to reiterate our wonderful speakers, we have with us Mitchell Avila Katine, who is, or was, excuse me, who was the lead attorney who represented the Lawrence v. Texas case all the way almost to the final decision. And then, of course, Paul Smith, who was representing the case at the Supreme Court. And these gentlemen have fantastic and storied backgrounds, ones that I can't emphasize enough. Mr. Smith is, of course, a very well-renowned Supreme Court scholar who has represented, I believe it's 21 cases now before the Supreme Court, and we may have to steal you again for a case later. I'm very, very interested. And of course, I can't sit here and list all of his many, many accomplishments, but you can see his full bio on the invitation that we sent. And as well, of course, Mr. Katine, who is literally the leading star regarding some of the best or some of the most well-known issues regarding gay, lesbian, bisexual, transgender issues. And he is a great lecturer as well and still practicing as well. So we look forward to more and entertaining cases from you as well. So with that, gentlemen, is there anything I missed that you'd like to sort of mention as part of your intro here before we get into setting the scene for the case?
I think it's appropriate to acknowledge that actually Lambda Legal was the lead attorneys on the case. I'm what you would call the local counsel. So I was the local attorney. John Lawrence and Tyrone Gardner came into my office when they got out of jail, and I worked closely with Lambda Legal. They are the constitutional scholars that took it from the beginning to the end, and I went along with them and assisted any way that I could. So today, on the 17th anniversary of the decision, I think appreciation should be given to Lambda Legal and all of their lawyers who are fantastic and who deserve a lot of credit for this as well.
Thanks for that, Mitchell. I really agree. Lambda Legal was the driving force of this case. It's one of the great achievements of what is, I think, the finest and most important litigation arm of the gay rights movement. And they actually were lead attorneys in the Supreme Court too, even though I ended up arguing the case. But I want to wish everybody happy June 26th. It's our day to celebrate great things in the Supreme Court. And I always enjoy spending June 26th with my friend Mitch Katine, celebrating what we were able to accomplish together back 17 years ago.
Excellent. And I too would like to emphasize the role of Lambda Legal in this decision and in many other landmark decisions on the topic as well. So I would like to again offer our thanks for both of you gentlemen coming on and joining us for today's session. And Ken, I'm going to turn it over to you.
All right, I want to second what Aaron was saying as a person who grew up in the Deep South and who is now about to get married for the first time and hopefully the only time to his same-sex partner in December. Decisions like these really impact my life personally, and I think the lives of many on the line today. So let's move to the meat and potatoes of why we are here. Let's talk about what the law was before Lawrence, and then if I can put you on the spot, give the audience a general overview of the Lawrence opinion. So of course, first we have Griswold v. Connecticut in 1965, which protected privacy in the bedroom for married couples as it concerned contraceptives. Then we move in 1972 to the Eisenstadt case, that while pragmatically extending privacy protections around contraceptive use to unmarried parties, seemed to be the first sort of notice we received from the court of the expansion of equal protection to previously underrepresented groups in the surrounding jurisprudence. The court is noted for saying that the framers of the Constitution know, and we should not forget today, that there is no more effective practical guarantee against arbitrary and unreasonable government than to require that the principles of law, which officials would impose upon a minority, must be imposed generally. Courts can take no better measure to assure that laws will not only be just, but to also require that laws be equal in operation. Then unfortunately, we get the Bowers v. Hardwick decision in 1986, which declared constitutional the Georgia statute criminalizing sodomy and held that the constitutional promise and protections we thought Eisenstadt was developing when they said that the case was restricting those decisions to the fundamental individual right to decide whether or not to beget or bear a child. So this is my first question, putting you both of you on the spot. With Lawrence v. Texas, what did the opinion in Lawrence v. Texas do that you think corrected the errors left behind by Bowers?
Well, first of all, it overruled Bowers. It said you do indeed have a right not to be put in jail just because you choose to have sex with your same-sex partner. And it recognized that the logic was of going from Griswold to Bowers was all true, that it doesn't make any sense that you have a right not to a right to choose to use birth control or not to use birth control, but you don't have a right to choose or not to engage in sex. That's an area fenced off from government interference under the Due Process Clause. And so a lot of harm was done by Bowers for a long time, but it got fixed in Lawrence.
Well, I think something that is significant is they didn't just overrule it by indicating, well, now we're going to go here. They said they were wrong. They acknowledged that it was a wrong decision. And I thought that was remarkable for them to kind of say, we made a mistake and now we're correcting it. It took them 15, 16 years, and a lot of people, whether they were getting divorced or in employment, had to deal with that mistake. And you know, some people, when as we were working on this, were concerned that it might be too soon to ask them to reverse a prior decision. but it wasn't. And that, I thought that was very mature of them to acknowledge that they had made a mistake and that they were now correcting it, and then went on with Justice Kennedy. I think we should at the beginning acknowledge and appreciate Justice Kennedy for all he did. He wrote all of the LGBT decisions that we're celebrating today, all of the June 26 decisions. And so in Lawrence v. Texas, for those of you who don't remember it or haven't read it, Justice Kennedy uses glowing language, very elaborate, artistic language to describe the freedoms and the liberties of LGBT people. And it's just a foundation that can be built upon.
Perhaps it would be useful for a minute just to talk about why the movement was so focused on these sodomy laws that made it a criminal offense to engage in same-sex sexual activity. It wasn't so much that people were prosecuted under them very often, but they were a very finely tuned instrument of oppression and keeping people in the closet, because it meant that if your state had such a law, if you were openly gay and said, I have a partner and we're living here on Main Street, you were admitting to being a felon. You could lose your job, you could lose your children in a custody dispute. And so they were useful in that way. And they were, of course, the reason why bars kept getting raided all those decades, because to be in a bar and propose to take somebody home was to propose the commission of a crime. And so when Bowers upheld these laws, it was a terrible blow to the movement. It meant that the Supreme Court had said essentially there's nothing the government can do to you as a gay person or gay or lesbian person that has any constitutional problem. And so for the next 16 years, the target had to be to get Bowers overruled. And they went about it by trying to chip away at the states that still had these laws to get it down to a smaller number, down to about 13, I think, by 2003.
And the lawyers on the case were talking with the lawyers who handled Bowers, because that was the last case. And I will tell you, one of our concerns was because they thought they were going to win Bowers. They thought that was going to be a landmark decision, and so did we. But we thought, oh my God, if it happened then, could you imagine if we would have lost Lawrence versus Texas and we had another terrible decision? What would life have been like? But we knew that could have happened until oral arguments, and then we felt much better, right, Paul?
Right.
Well, very much so. And I do concur that a second terrible decision right after the first one would have been terrible for the movement and would have been terrible for the jurisprudence as well.
All right.
I think we should also mention that Sandra Day O'Connor was the only justice who was on the new court that we had that was on the Bowers v. Hardwick court. And although she sided with the majority, she didn't join the opinion. She wrote a concurring opinion. Paul, you might want to, I thought that was interesting.
Right. She's the only justice who switched sides between Bowers and Lawrence. And she did it by saying, well, I may have been right in Bowers about the due process, but I've got my own theory under equal protection. And so I'm going to find a way to vote for the good guys this time, even though I didn't in the first case.
Hey, well, I have to say that I just learned a lot just from the overview. So this is going to be a lovely 90-minute session. All right, gentlemen, I would like to now turn your attention to one of the areas that I know the least about, which is the backstory that led us to the litigation. So if you don't mind, I'm going to pose a few questions, and I would love if you just stream of consciousness away it, if you don't mind.
We're there.
So,
First
question. The initial circumstances that prompted the police activity that resulted in the arrest and charges in this case are unfortunately familiar to this current time. Can you tell the audience a little bit about that initial call?
Okay, so I'm going to go ahead and tell you what I believe really happened, okay? And you're probably going to hear it for the first time here. Here we go. John Lawrence was friends with Tyrone Gardner and Robert Eubanks. Tyrone Gardner and Robert Eubanks were a couple. And Robert Eubanks and Tyrone Gardner were moving into and John Lawrence was giving them some furniture for their new place. And so they were drinking and having a dinner and evening in John's apartment. And John invited them both to stay over. Say, just stay over. We'll wake up early. We have a U-Haul outside, and you can take my furniture. Tyrone thought that was a great idea and said, okay, I'll stay. Robert Eubanks said, I did not. He did not want to stay. He wanted to go home and come back in the morning. Tyrone said, you go home. I'm going to stay here with John. Robert Eubanks got upset and said, okay, I'm going to go downstairs and get a Coke. He even asked John for a quarter or 50 cents to buy a Coke. So he went downstairs pretending to buy a Coke and called the police. And Robert Eubanks told the police, there's a man with a gun in the apartment, come quick. And when the police arrived, John showed them where, Robert Eubanks showed them the apartment, and the door was open. And as I understand it, the police entered the apartment with their guns drawn. Now, the facts at this point vary. According to the police, they entered John's bedroom and observed John and Tyrone engaged in anal intercourse, and they looked up and saw the police and did not stop and continued engaging in anal intercourse with the police in the room, and the police had to pull them apart and then arrest them. That's the police story. John and Tyrone's story is that John and Tyrone were sitting on the couch in the living room in their underwear, getting ready for bed, watching the news. The police entered the apartment and looked around, saw some gay pictures on the wall, some sketches and drawings, figured out that they were gay, started using gay slurs, calling them names, and deciding that they were going to teach them a lesson and go ahead and arrest them. They let Tyrone put on his clothes. They handcuffed them all. They realized Robert Eubanks was made a false police report, which is a crime, and arrested them and dragged John down the stairs. He was not going happily. He was upset, and it was a very rough arrest. John tells me that he just couldn't believe this was happening, and he wasn't going peacefully, although he was not charged with resisting arrest. And then what happened next is it was about 1 or 2 in the morning, and the sheriff's officers were trying to call the DA because a DA had to accept the charges in order so they could be booked in jail, and they couldn't get anybody to accept the charges. They eventually did, and they were put in jail for 24 hours. The sole charge was violation of Texas's homosexual conduct statute, which is Penal Code 2106. And that is what I understand happened as to how they were arrested. Of course, when we heard this at the very first meeting that I had with them, they had to understand that in order to challenge the statute, that we had to plead no contest. And that was very difficult for them. They were really never happy with that, but they understood it was important, and that is the status. They got convicted on their no contest, and then the case proceeded. Any questions?
Well, no.
It's an unusual Texas procedure that says you can essentially plead guilty to the facts but contest the constitutionality of the statute, and that's what they ended up doing. And there's a wonderful book by law professor Dale Carpenter called Flagrant Conduct that lays out the story in great detail after interviewing all the police. And he says there were four cops there. 2 of them saw no sex, 1 saw oral sex, 1 saw anal sex. It's pretty clear that the Lawrence and Garner version of events was what was really going on. Although I must say, I was completely unaware of that until years after the case had been decided. I think maybe the people who knew more about it decided to keep me in blissful ignorance. And we also didn't have much Lawrence and Garner talking to the press as the case proceeded, in part because nobody really wanted them to be perfect spokespeople, and they wouldn't have been. But also, I think maybe this aspect of the story was probably, well, it didn't have any legal significance. They'd been convicted of this conduct, violation of this very discriminatory law. It wouldn't have been particularly good for the sort of aura of the case, I suppose, to have that out there.
It would have been a distraction, I think. I think it would have been a distraction.
Would have been a distraction. the Texas homosexual conduct law was remarkably good target. It had been passed in 1972, so it was fairly recent. Just as Texas had completely decriminalized all other aspects of sex, adultery and fornication. There was nothing that straight people could do that was illegal, except for obviously compelled sex. But they passed this law to say, but you gay people, you don't get to do essentially anything with each other. And so part of the case as it proceeded was to say, well, you're discriminating against LGBT people. And part of it was the argument going back to Bowers that there's this area of liberty that ought to be shielded from government interference. People should be able to make their own choices in the bedroom.
Excellent. Excellent. Well, I actually do have a follow-up question going back to just the part you mentioned about getting someone to accept the charges and then pleading nolo contendere to that. My understanding of the case procedure, and please correct me if I was wrong, is that it originally went before a magistrate judge and then was appealed from the magistrate judge to the actual trial court of record. And that was because in order to be appealed beyond that, it had to make it to that first trial court level. Can you tell us a little bit about the circumstances, what had to happen procedurally at that stage in order for the case to proceed up the chain of appeals?
Well, I do think it's interesting that this was a Class C misdemeanor. So that's one of the lowest charges. And so we started in the Justice of the Peace Court. And, at that time, almost all of the judges in Texas were Republicans. The appellate, the county court, the district court, the Supreme Court were all Republicans. And this was maintaining the sodomy statute was a plank in the Republican Party that they felt very strongly about this. The district attorney was Republican. But I do think the Justice of the Peace, the very first judge, may have been a Democrat. And so it was a little scary because the Democratic judges try to be a little more accommodating and nicer, and we were afraid that they might even dismiss it. So we pled no contest. We weren't contesting it, so we couldn't find us not guilty. But as I recall, the original fine was like the lowest fine there was, which was $100. And Suzanne Goldberg with Lambda Legal flew down and was with us, and either she made a call or she realized as we were walking out of the courtroom that you cannot go to the Supreme Court unless you have an original fine of $250 or more. So before we left, we actually went back into the courtroom with the prosecutor and told the judge that we wanted him to increase the fine from $100 a person to $250. And I think he said he had never had anybody ask him to do that, but he did it. And so he actually, granted raised the fine for $250 per person so that the case could proceed on forward. There was also another procedural thing that was interesting is the next level court, you have a trial de novo at the county criminal court, and it actually landed in a Democrat. A Democrat had been elected to a Democratic court, and due to the politics of that, the case was actually transferred to a more longtime Republican, very nice judge, but it actually had to be transferred to that judge so that he wouldn't suffer any political backlash by finding our clients guilty. So politics, as you're going to hear as we get into the Court of Appeals and the district attorney, this case was very political. I think Senator Santorum and President Bush actually commented on this case as it was spending its 5 years. The Republican Party was very invested in our clients being convicted. And as we'll talk in a few minutes, there were times where we could have either won at a low level or the case could have been dismissed. And we would have never made it to the Supreme Court. I would have never met Paul Smith. But the Republican Party would never have that. I guess I'll just go into it. At the 14th Court of Appeals, we won. We won on a three judge panel under the Texas Equal Rights Amendment. And the Republican Party issued a press release, sent letters, and said, if you don't reverse this, we're going to run people against you and you're going to lose in the next election. And we actually had an inquiry by the Texas legislature, an all-day hearing as to whether those letters that were sent to the judges constituted its own criminal violation of threatening judges based upon an opinion that they issued. As a result of all this politics, the 14th Court of Appeals granted the prosecutors application for en banc review, granted the en banc review, reversed the panel, and found, and we lost, I think, the two judges who were in the majority on the panel were the two dissenting judges on the en banc review, and our clients were still convicted, and we moved forward to the Texas Court of Criminal Appeals, which is the Supreme Court for criminal cases in Texas. I hope that wasn't too long of a narrative.
No, I
No.
said I wanted a stream of consciousness, and that's exactly what we all deserved, and we wanted. So I have a question for both of you about one of my favorite topics, which is stances on punishment. So do either of you have a particular stance on appropriate punishments for misdemeanor level crimes, especially those related to sexual conduct?
And this is just in the line of, are there other cases that could have been impactful, but that are currently caught or are not making it up to an appellate level of review simply because the punishments that are being imposed don't allow them to proceed in that legal manner? Or are the punishments that are being imposed of the type that can't be appealed? There are fines that are too low, things of that nature.
You know, I guess my view about this is that for this kind of law, the degree of punishment was the least of the problems. It was that you would have a criminal record, and at least in some states, you would be forced to register as a sex offender. And so even though this homosexual conduct law, at least as applied here, had a very small amount of punishment, the principle of the thing was extraordinarily important. People didn't want to go through life, the rest of their life, as a sex offender. You know, I don't have a particular view about what the right level of punishment ought to be. The consensual sexual behavior, happily, since Lawrence, is constitutionally protected, so you don't have any penalties for it. As long as it's private, consensual to adults, that you have the right to do whatever you want, which is what the case stands for.
I think there are a couple of other things that are interesting, and that is the sodomy statute was the same type of crime as not wearing a safety belt. Same level crime in Texas. And it was in the discretion of the police officer as to whether you just give them a ticket or whether you arrest them and bring them to jail. And I can confidently tell you that if they had just given John and Tyrone a ticket, they would have never called me. They wouldn't have been upset. They would have gone down to the JP court, fought the ticket, and none of this would have happened. It was that arrest and having to go to jail that angered them and said, this was not right and we want to do something about it. I also understand that had we not won, they would have been in Texas considered sex offenders. Had we not won at the Supreme Court, we lost at every court in Texas. Had we not won at the Supreme Court, they would have had to register as sex offenders for the rest of their lives. And honestly, had I known that at the beginning, because, you know, who imagines they're going to go to the Supreme Court and win? We probably wouldn't have gone all the way, but I wasn't aware of that. I will tell you after the Court of Appeals, that not the court, the county court at law where we lost, before they allowed us to leave the courtroom after they were found guilty, the bailiff came over and said, I need to fingerprint you guys now. And we were all kind of shocked. You know, fingerprinting them was pretty serious to me. It kind of said, oh, this isn't just fun and games. They're being fingerprinted now as convicted criminals. And I got very worried at that point, because I knew that this was a a lot more serious than I had anticipated.
Right, and I think we should stop to recognize the courage that it takes for people like John and Tyrone to come from obscurity, leading ordinary lives, and decide they're going to take on the role of being the guinea pig for what we hoped would be a hugely important victory, but nobody knew. And they were relatively private people about their sexuality, and in that generation, it wasn't like you wanted to be on the front page of the paper as the two most famous gay people in Texas for a period of time. But that's in fact what they took on. It was a courageous act.
For some reason, the Republican Party would always say, "This is a setup. This is a setup. This isn't real," as if that would minimize their arrest. But I can promise you and tell you that this was not a setup.
Right, but they liked the laws to work the way they usually did, which is you didn't arrest people for this crime. You just had it hanging over their head so they wouldn't get too uppity, those gay people. They wouldn't think they could run for office. They wouldn't think they could be too out. They wouldn't. You knew that they could be kept in a second-class citizenship status, and that's what they liked about it. And George W. Bush ran in support of these sodomy laws against Ann Richards. There was an effort to get rid of them for years before this, but the Republican Party simply wouldn't do it.
I guess I want to mention that John and Tyrone have passed away, but this was a highlight of their lives. They were treated with respect and appreciation. And also, when I talk to college students and law students about this, people are always worried that, if I come out, what's going to happen to me? And what I like to tell people, in all the years that John and Tyrone were out and being unafraid, they never had one negative experience by any person or call. It was all appreciative. Nothing ever bad happened to them, even though everybody knew who they were, and they were public about proceeding on this case. So I try to use that to encourage people not to be afraid and to stand up for what is the right thing to do.
So I think both of you already answered the question I'm going to pivot to, which is kind of picking your brain from an idealism perspective. The question is, what made you take this case? What made you realize this was the case? Or did you not know when you took this case that it would be this impactful?
Well, they've been looking for a case like this for years. They're having laid the groundwork since Bowers back in '86. They needed a case where people actually were arrested and prosecuted to go to the Supreme Court and try to get Bowers overruled. So the case was kind of a wonderful, lucky break for the gay rights movement. By the time it came along, you had these great facts of these two guys being arrested in their underwear and prosecuted for what was alleged to be adult consensual in a private home sodomy, not something that comes along every day. By that time, the movement kind of knew that they had a somewhat different court, with Justice Kennedy having already written an important a pro-gay opinion in a case called Romer versus Evans. And so there was a real excitement when these facts came along. And I think even at the beginning of the case, people in Texas realized this might be the one that would go all the way, and that needed to be preserved and make sure all the I's were dotted and the T's were crossed to make sure that the case could in fact be brought all the way up if the Texas courts didn't show the wisdom to actually reverse the convictions themselves, which they almost did, but then they didn't.
I kind of had a little different perspective on this. I actually didn't think we were going to win. And I often told John Lawrence, this was very frustrating to land illegal, but I felt that it was important because just like in employment, like the recent employment decision that came out, many people said to me, well, I didn't know it was legal to fire people for being gay. And so when Lawrence versus Texas hit the front page of papers around the country, I was fielding calls from England and France and Germany and California. California, New York, they could not believe this was really a law. They said, did this really happen in 1998, that two people were arrested for having sex in their home? And so I saw this as an educational opportunity to let people know that this was still there, that this was still happening, and that it was wrong. So that's what I thought, is that this would help educate people of what it was like for gay and lesbian people, and winning the case was icing on the cake. But
when they came to our firm, which was at the time the Texas courts had finally said, no, we're not going to help you. The question was, should we go to the Supreme Court or not? Is it safe? Are we going to make bad law? And the advice we gave was the Supreme Court doesn't have to take cases. They take the cases they want. It's completely discretionary. And we didn't think there was any reason for them to take this case if they were just going to affirm the conviction and say 16 years later from after Bowers, yes, we still hate your guts. We still think you have no constitutional rights. And so our instinct was, we have a somewhat different court, and they will just deny cert unless they think there's a good chance that 5 of them will actually overrule Bowers and say that this is an unconstitutional conviction. And in many ways, the most exciting day, although there were many in the Supreme Court phase of this case, was the day we found out they had in fact granted review in the case back in 2002, because then we suddenly realized, oh my God, we're going to make history here. We really have a very good shot at winning, because there wasn't any reason for them to otherwise just take it to say, we still hate you. We thought people would sort of figure out, is Justice Kennedy going to be okay? Is Justice O'Connor going to be okay? Because if they were, the Bowers case was just despised by a whole generation of young lawyers who came along and said, this is just disgusting that you can be convicted for this. So we were reasonably optimistic once the case was taken, and we didn't see any real downside in the Supreme Court. Either they would just deny review, or they would take it and we would have a really good shot.
And certainly, I don't know if you want to talk about it now or later. I'd love to for Paul to mention how well oral arguments went and how good we felt after oral arguments.
Well, it's sort of skipping ahead a little bit, but we did. The oral arguments were somewhat one-sided, I say immodestly. I was the veteran who'd done a lot of this, and I had been prepared to death by the Lambda team with practices and practices and practices, because we knew we were in a case where we were making history. We felt like every scrap of paper ought to be saved for the Smithsonian, and indeed, the truth is, my binder from the podium that day and the necktie I was wearing are in the Smithsonian, believe it or not. But the district attorney from Harris County had never argued anything like this before, and he wasn't really equal to the task, I'd have to say. So it was I think the New York Times said it was a match of unequals seldom seen in the Supreme Court. So that made us feel better. I mean, obviously, I don't know that the quality of the argument is how the Supreme Court decides what they're going to do. And this is probably a case that by the time we got to oral argument, all 9 justices were completely sure what they thought about whether Bowers was good law or not. But it was nice to have a good showing in the courtroom that day. And it almost felt as if we were arguing for the community, to make sure that when they had their one opportunity to speak truth to power, it wasn't squandered or screwed up in some way, that they at least knew that they'd had a chance to say to the court for half an hour, this has to end. You can't continue to treat us like we have no rights at all. Happily, that worked out really well.
And
fantastic.
Us that were sitting behind Paul, as different questions were asked, we tried to, you're supposed to stay quiet at the Supreme Court, but when I think it was Chief Justice Rehnquist said, well, if we get rid of the sodomy statute, won't that allow kindergarten teachers to be gay? And
yeah,
we gasped. It was like, did he really say that?
That was actually a very hard question. I mean, first of all, it did upset the crowd, but it also, I thought, it was going to take us off in a different direction about teaching and stuff. And it sort of almost conjured up the idea that the worst thing you can do is have gay people around children, that they're going to either recruit them or distort them or abuse them in some way. And I didn't want to get into all of that, but I had to give some kind of answer. And of course, first thing I said was, well, they'd have to have some reason why they wouldn't let gay people be kindergarten teachers. Thinking in my mind that there's probably 500,000 gay kindergarten teachers right now in the United States. And Scalia decided he would supply the reason, which is, if we let them teach kindergarten, they're going to turn the kids gay. And that's when the crowd really went, whoa, that's the stupidest thing I've ever heard. You really don't hear those kinds of demonstrations very often in the Supreme Court. But that comment from Scalia really offended people, I think, because it was so obviously absurd to think that exposing a child to a gay person with all the straight people they're exposed to in their entire lives is suddenly going to change their sexual orientation. It's absurd.
And one of the other very memorable moments when Justice Ginsburg asked the district attorney, isn't it true that you have a law that allows gay people to adopt children in Texas? And what is the sodomy statute and allowing gay people to adopt children? And just coincidentally, my partner Walter Avila and I had adopted our 2 children that same week. It was a very busy week. So we had adopted our children, who are now 17 and a half years. It's been 17 years since Lawrence. But she asked that question, and I don't know how often this happens, Paul, in Supreme Court arguments where the district attorney said, I don't know. I don't know the answer to your question.
You really don't want that to happen. That's why you want to have a lot of practice and have veterans who know what they're doing do the arguments. But no,
Right.
It was an obvious question, and he should have known the answer. And it put him in a box because it really made no sense for Texas to say, we're going to place foster children and adopted children in people's homes, but we're going to arrest you if we find out you're having sex in your own bedroom. There were many weird things about that argument. That the other one that I remember all the time was the Scalia hypothetical about flagpole sitting, which is, I'll have to sort of set this up a little bit, but one of our arguments was that you should be more willing to hold these sodomy laws unconstitutional because most of the states have gotten rid of them. And it's clear the American people have turned against the idea that states should be regulating adult behavior in the bedroom. And that ought to inform your analysis of what liberties ought to be protected under the Due Process Clause from government interference. And Justice Scalia is not a believer in the idea that the Constitution evolves based on what states repeal and that sort of thing. And so he decided to dramatically illustrate that by saying, well, what if back in the 1920s, it was a crime to engage in flagpole sitting, which was this thing where young men would climb up to the top of flagpoles and sit there for 24 hours as kind of a stunt. And he said, and then most of the states repealed those laws. Does it suddenly mean you have a constitutional right to engage in flagpole sitting? And, this was just a way to, I guess, illustrate his point that the law doesn't change based on what states have repealed. But you think about the example of the conduct he chose to bring up, given the subject of the case being anal intercourse. It was just I've never to this day been able to figure out whether it was one of the most amazing Freudian slips or aggressive intentional harassment of our side. But that's another time when the crowd was like,
I am literally laughing so hard over here. I did mute myself for a second. It had never occurred to me that might have been that size of a Freudian slip. My goodness. But seriously speaking, and speaking of another area where the 2 sides were perhaps a little bit unequal in their presentation to the Supreme Court. One of the things that Lambda Legal did that was fantastic for the case, from my perspective at least, was the coordination of their efforts on the amici. So all of the letters and all of the statements and arguments that were being made from not just the perspective of the rights, but also from the perspective of the collateral consequences that were involved, and pointing out the various hypocrisies and things of that nature that were involved with this case. The response from the other side was not as organized, let's put it that way, as the response coordinated by Lambda Legal. Do you think that had a major impact on the case? And also, more generally speaking, what is your opinion, as it were, on these amici briefs? Are they something that are of value to the court? Are they something that should be this coordinated? Things of that nature.
Well, let me just say, first of all, what our strategy was. We were trying to appeal to at least one of 2 people, Kennedy and O'Connor, who were kind of centrist Republican, pretty conservative people. And the goal was to communicate to them that the principle that the Constitution protects gay sexual behavior is mainstream, is respected, has become what the American people believe is right. And we did that by getting extraordinarily mainstream groups to file these amicus briefs. Every big organization from the American Bar Association, American Medical Association, lots of well-respected groups like that. And then we tried to recruit every large law firm, the really well-known national law firms in the country to author each of these briefs. And the truth is, by 2003, the firms were falling all over themselves to be on our side. Very different than back in the 80s in Bowers versus Hardwick. So we had a very robust selection of these amicus briefs. And they play a really important part in the Supreme Court by sending various messages or providing information the court needs that the parties can't provide. The briefs on the other side, there was a handful of amicus briefs. They were really just awful. I mean, there were no mainstream groups you'd ever heard of. There's no law firm you've ever heard of. They were extremely homophobic in various aspects. One brief spent pages describing in detail what gay sex is like. One was all about AIDS and the notion that the reason why we have to ban all this is because gay people get sick more than everybody else. Or there was a whole brief about how gay men are less likely to be or more likely to have extramarital affairs than other people. So, I mean, it was really just a shameful performance that I think hurt them, because the moderate justices wouldn't like that sort of thing. It wasn't the kind of thing they would have liked to read. And so we definitely won on that front as well.
All right, gentlemen, I'm going to ask the can of worms question. You alluded to it earlier, but I'm going to go ahead and outright ask it. One of the common arguments that comes up in LGBTQ cases is that granting rights for gay and lesbian couples and others is the beginning of a slippery slope situation where decriminalization of certain behaviors could lead to decriminalization of other behaviors that are undesirable. Usually the argument begins with bigamy or incest. How do you answer those questions directly? How do you see that type of argument being dealt with? Where do you see the weaknesses in that type of argument?
Well, the slippery slope, as they call it, argument was a big part of what we were concerned about at the time. Not only marriage, which we thought we didn't want the court thinking about that, but also these other things that could be, at least some people had said were comparable to sodomy. Bigamy, incest, prostitution, things like that. And so we had an answer for why each of those laws were meaningfully different from a law that simply regulated what two adults do together. Prostitution is a commercial aspect to it. Incest, there's a whole sort of exploitation of one family member by another family member. Bigamy has to do with breaking the contract of marriage that the state has established. But you know, these were not always easy things to figure out, and why it is that you should have a right for two people to have sex or to live together, and not three. Polygamy was was not the easiest answer to script. But at the time, this was one of the big things that the conservatives were trying to do to push back. Senator Santorum had said, if we win this case, then it's going to be a constitutional right to man on dog sex, and that's why we should lose. And so the slippery slope was an issue, but the truth is, I don't think it ever really impressed the court very much. They knew that they weren't going to legalize prostitution or incest just because we won this case.
And I actually would like to say that there are some decisions that the Supreme Court issues that are very narrow. I actually don't think Lawrence versus Texas is one of them where it's very narrow. I think that the law, and Paul, I don't know what you think, but I think there are some more broad right to privacy. I think one of the things that Lawrence versus Texas did, which said that moral disapproval of a criminal statute is not enough as a legitimate basis for a criminal statute. that's actually a pretty broad concept that can be used and should be used to look at other criminal statutes. In fact, one of them, we were talking before we started here about the underage sex statute, where in Kentucky, there was a statute that said if you have underage sex with someone of the same sex, your penalty is greater than if you have underage sex with someone of the opposite sex. And that's an example where disproportionate penalty and punishment is applied to someone based on the same sex conduct. And the right to privacy, the point that if it's not hurting anybody and there's no harm occurring, what consenting adults do, not for money, in the privacy of their home, should be protected. And I must say, in talking with a number of my Republican colleagues, that's a concept that they like. The Republicans want less government. So although some decisions, like the Supreme Court Master Baker cake or whatever it was called.
Masterpiece Cake Shop, yeah.
Right, that I consider that to be a very narrow decision based on what occurred there. Lawrence versus Texas is a broader decision that I think can apply to more situations and has and may continue to do.
Well, yeah, let me just add on to that one of the most important aspects of the decision was the holding that the government doesn't get to treat gay people differently from straight people because it has moral views about whose orientation is better morally. The essence of the decision was that in the United States, people get to choose their own family members, their own sexual partners, their own family members, and they don't have to go to the government for approval of the morality of the choices they've made. They can set up their own families the way they want to. And we did talk really more about family than about sex in the briefs. We were trying to get Kennedy and O'Connor to think about the sexuality at issue here as a foundation of long-term relationships, just as it is in the heterosexual marriage context, that it's a valuable thing. It's not merely a sort of sorted little coupling somewhere, but it's part of people's forming families. And we were assisted in this by the fact that by 2003, the world was looking at gay couples very differently. Back in the 80s, nobody knew that there were such things. There was a great deal of misunderstanding, and people had been, precisely because of the sodomy laws, kept in the shadows. But because of AIDS, because of cultural evolutions of various sorts, people knew by 2003 that there were hundreds of thousands, if not millions, of gay couples out there raising kids. And so we were talking about those families and saying, why is it that the government gets to have a view that they're less worthy morally than anybody else? Why shouldn't individuals in this country decide who they want to marry, decide who they want to be with in their lives? You don't have to go to a commission somewhere and say, is it okay if I get married to this person or that person? And you shouldn't have to. And the other thing I was going to say about Mitch's comments is it is true, in fact, that by 2003, everybody in the United States was pretty shocked at the idea that the government could arrest you in your bedroom for something you've done with another adult, non-commercial behavior. It was one of the reasons why I think the conservatives, anti-gay side of the movement, anti-gay movement, kind of abandoned the field in this case. They didn't show up at argument. They didn't really file much in the way of amicus briefs. I think they were sort of embarrassed that this law actually still was on the books and was being enforced. And an indication of that is that on the day of the decision in June 26, 2003, Rush Limbaugh immediately launched into his kind of usual screed against the liberal Supreme Court, saying this was a terrible thing. And his own listeners, I understand, I would say I wasn't listening to Rush Limbaugh that day, but I'm told that his own listeners called in and told him he was crazy, that you can't have the government coming into people's houses and arresting people for what they do in their own beds with another adult. This is just not American. And what that meant was that for the rest of the time when people were litigating the constitutional rights of LGBT people, the government was deprived of its main argument, which is gay people are morally inferior. The reason why we want to discriminate against them is because we value these other couples more because they're straight, and we devalue these couples over here because they're same sex or gay. And having lost that justification, which was in fact, of course, the real justification for why the law for years had discriminated against same-sex couples, they were in a very difficult position in trying to defend against other forms of discrimination, like the denial of marriage equality. And so that's really the most important thing that Lawrence made extremely clear, which is the government doesn't get to have a point of view about your family. Your own relationships. Those are decisions Americans get to make for themselves. And the person who thought that was really awful was the person who wrote the dissent, Justice Scalia, because he recognized that once you take that moral justification away and say that whatever you're going to do in this area can't be based on a moral differentiation between your judgments about these people and these people, then you're not going to have any justification left for discrimination. And he predicted in his dissent that the Lawrence opinion will, in fact, lead to marriage equality. If you think this case is just about the right to have sex with each other, you don't understand where we're going, or you don't believe in the law having any logic. He said the logic of this opinion is that eventually the states are going to have to treat gay couples the same as straight couples, give them the same respect and protections as everybody else gets. And it took 12 long battling years, but that's exactly what happened. And so that, I think, is an extremely important aspect of it, which, thank you, Mitchell, for bringing up this issue of morality as part of what was going on here, and the central part of it. Whether the case stands for the proposition that morality can never justify other kinds of criminal laws depends on your perspective, but certainly in the area of intimate family formation, intimate sexual behavior, the government's moral view no longer has any role to play, and that's enormously important.
And in fact, in the 2015 Obergefell decision, they cite to Lawrence. They talk about Lawrence in that opinion. It was very gratifying to see the Lawrence decision continued on in the Obergefell decision.
Well, even if you go back to 2003, about 5 months after Lawrence, the first big marriage win was the Goodrich case, the Massachusetts Supreme Judicial Court, holding that under Massachusetts Constitution, there's a right to marriage equality, way ahead of anybody else. Enormously important decision in terms of getting to marriage equality in less than a generation. And the first 2 or 3 citations in that opinion are to Lawrence. It was, they were. It's hard to know whether this is true or not, but it may very well be true that the 4-3 decision in that case, which was so pivotal in actually getting people the right to marry and having America see people marry as they did in 2004 in Massachusetts, whether that would have come out that way if Lawrence had not preceded it just by 6 months and sent a very powerful signal to judges of all sorts that there's a new age here in terms of how gay people are going to be viewed in the law, under the federal Constitution in Lawrence, and then it turned out under the state Constitution in the Goodrich case. And that became the first of many battles of going state by state over the next dozen years or so, trying to build up enough of a critical mass of states where there was marriage equality to go back to the Supreme Court. And happily, everything worked out famously. It just took a long time. At least some people would say it took a short time. Some people would say it took a long time. Whatever it was 12 years from to the day from Lawrence to Obergefell.
All right, gentlemen, I'm going to touch on one of the topics that you just mentioned, which is politics and the different parties that are involved in this case. And I'm actually also going to touch briefly on the independence of the judiciary, but also how they appear in terms of politics. And I'm going to actually drag you back to an earlier point in the case for just a moment. This is going back to when the case was before the step just before the Supreme Court, when we were talking about the Texas Court of Criminal Appeals. They had decided eventually to not issue an opinion and to let the opinion of the en banc court stand for this particular case. Right. And at that point, that was a very unpopular decision with both sides of the case. Bill Delmore of Harris County as the prosecutor at the time, and Lambda Legal's counsel, Ruth Harlow, both issued very strong opinions. I believe the quote from Ms. Harlow was that the decision was an absolute abdication of responsibility, and Mr. Delmore indicated that the justices involved were gigantic chickens. And that kind of opinion was some of the tamest that was involved with this particular case. As you noted, there were strong letters and possible investigation of pressure and things like that from the various parties involved. And again, this matches some of the controversy lately where there's been very strong opinions or very strong statements being made about decisions from the judiciary. So do you or would you like to opine on this particular situation where there is political influence in addition to the following findings of the law, how that affects the cases, how it should affect the cases?
Well, I know this is going out to a national audience, and different states appoint and elect judges differently, but our judges here, all the way from the JP judge to the Supreme Court judges of Texas, are all run on a party platform and are elected. And over time, often there are complete sweeps where very good qualified judges are removed. I must say that most regular non-lawyer people don't really know about judges or who's good or who's bad. And I also want to say that most political issues are about contracts and real estate and money, and they don't involve Democratic or Republican values. Yet, unfortunately, when the judges run for office here in Texas, they have to solicit and court either the Democratic or the Republican Party and try to get their endorsement so that they can win these elections. It's a terrible arrangement, let alone judges asking all of us to contribute to their political campaigns. And the judges don't like it either. They like to get elected. I will tell you, I practice litigation, and I do real estate, homeowner association, and other things like that, just the day-to-day type of stuff. I've been in a number of courtrooms where, for whatever reason, my case is being held until the very end, and I'm sitting there alone in the courtroom with this judge, and he said, "Mitchell, I wanted to wait until everybody left. I want you to know that I'm very happy about the Lawrence case, and I think it was the right decision, both civil and criminal judges." And they said, "But I can't publicly say that. But good job. It was the right decision." And you know, it's very nice, and I understand what they have to deal with. So in Texas, as opposed to, I don't know to what degree Paul as a Supreme Court professional will know better than I as to what degree do politics play into Supreme Court decisions. But I will tell you, until you get to the Supreme Court, politics is a big deal here. And when we won at the 14th Court of Appeals, the two judges who were in the majority temporarily before it went to en banc review were Republicans, and they got hell for their decision. Even though they believed it was right, we believed it was right, it was not politically correct, and the Republican Party came after them with a vengeance, and their lives were never the same. It was terrible. So that's the role politics plays in Texas judicial system.
Well, let me talk about the U.S. Supreme Court then in terms of how it responds to or doesn't respond to public opinion. I mean, there are other aspects of the Supreme Court you can talk about where it's being very political, like, you know, sort of deciding presidential elections and that sort of thing. But just in terms of whether the court is influenced by whether the decision will be popular or not, the reality is the court really likes to not get too far out ahead of where the American people are. They have a sort of limited amount of legitimacy and credibility, making these incredibly important decisions for the country. And they are much more comfortable when a decision is something that the American people readily accept as consistent with constitutional values, consistent with American values. And that is something that one takes into account in deciding what to ask the Supreme Court to do. If you think about the mistake that was made in Bowers versus Hardwick back in the 1980s, if the Supreme Court had said there's a constitutional right to engage in gay sex, it would have been a pretty controversial decision. By 2003, when so much had changed in terms of cultural attitudes, it wasn't controversial at all. I never got a single nasty letter, phone call, or anything for having argued that case and being so visible. Front page of photographs in the Times and the Post the next day, and it just wasn't particularly controversial. Now, marriage was different. It was extremely unpopular, the idea that same-sex couples could get married in 2003. But probably about only 1/3 of the country thought that was a good idea, and people were extremely upset about it. There were something like more than 15 or so states in 2004. The next year, they put ballot measures on the ballot to ban same-sex marriage in those states and bring conservative religious people to the polls. The theory being it was going to help Bush beat Kerry. And those all passed overwhelmingly, 70-30, 80-20 in those states. And so that was where it was, and everybody understood in 2003, even though it was obvious that the next issue was marriage equality, that to go back to the Supreme Court in 2003, 2004, and say the logic of Lawrence means you have to give us marriage equality. Justice Scalia even said that in his dissent. What was too soon. The court was not going to be willing to do something that fundamental to an institution of that importance to people. People felt it in their gut that it was an insult to them and their marriage to think that these same-sex couples could be viewed as equal. And what then happens is the movement spends the next dozen years not just litigating, not just trying to achieve victories in state courts around the country, which taught people a great deal. To see those people married in Massachusetts was an important lesson, but also doing calculated public relations campaigns. And what you saw was the public support for marriage equality from 2003 to 2015 went up 2 or 3% a year. A straight line just kept going up and up and up to the point where the court by 2015 knew that the country was 60-40 in favor. And that line of support for LGBT equality has continued to go up from 2015 to 2020. It's really high now. And then we haven't even mentioned the enormous victory for LGBT equality that happened just last week in the Bostock case, which basically read a federal statute that's been on the books since the 60s, Title VII, to ban employment discrimination against LGBTQ people in the private sector, something that hadn't existed for all these years in most of the states. And it seems to be inconceivable that that decision would have come if there wasn't, if the court didn't know that the American people were against employment discrimination against gay people, and are by 85-15 or something by now. I mean, people just like fairness and don't think that being gay or lesbian or even transgender is a basis for having anybody treat you badly. And so that cultural shift has given the court a great deal of running room and comfort that they can continue to be instruments of achieving greater equality for the gay community.
Paul, I was just like to see what you'd have to say about the fact that Justice Gorsuch wrote the opinion. I mean, we're talking about politics here. What do you make of Gorsuch as the author of that opinion? We were shocked, but it also made us feel a little safer that he's going to be more fair as we go forward. What are your thoughts?
Well, Justice Gorsuch is a believer in a particular method of reading statutes, which is you read the words, you figure out what the words mean. It's called textualism, and you don't think about what you suppose the people who voted for that law thought they were doing or intended to do or meant to do. That's wrong. You just look at the words, figure out what they mean. And he said, I'm looking at these words. You can't fire somebody because of sex. And that includes you can't fire somebody because of the sex of the person they're in love with. That the literal meaning of because of sex includes you can't fire people because for being gay or for having changed sex, coming in presenting as a different sex, that those things are within the literal meaning of the terms. And I think he probably relished the opportunity to say, I'm going to find a case in which my methodology produces the sort of liberal outcome but it shows that I'm a principled jurist. I'm not just a result-oriented right winger that just only cares about what the answer is. The bottom line is I want to have some coherence that I follow my methodology. But you know, the real motivations are probably very hard to figure out. It was encouraging not only that Gorsuch wrote it, but that Chief Justice Roberts joined it, who had read it. Roberts, who just 5 years ago had written a very nasty, sort of snarky dissent in Obergefell, saying, "Have your party, guys, but don't think that this is right. This is just wrong. You shouldn't have any rights under the Constitution to marriage equality." And so I think that both of them are swimming in a sea where the American people are so strongly against this kind of employment discrimination that probably reinforced what they did. But Gorsuch, you know, his opinion makes sense, and it follows this textualist methodology, which is very often marshaled in service of reaching a very conservative outcome. It just didn't happen to do so here. The three other conservatives who dissented in the case said, "You just got your methodology wrong, Neil. This is not the right way to do the textualism. Firing somebody because they're gay and firing them on the basis of their sex is two different things." But he didn't agree with that. And the result was a decision that extended protections for gays, lesbians, transgender people, bisexuals, to an enormously broader scope than they had been all these years. You know, we've talked for years now about how you could be married on Sunday to your partner and be fired on Monday when your boss found out about it. It was perfectly legal in 29 states to do that. But now you think about what this means for people in states where there were no protections at all from employment protection discrimination. It's absolutely enormous and a sign of how far we've come.
Excuse me.
Bless you.
We used to focus on, you know, the Price Waterhouse gender stereotyping. That's all we could do in employment is gender stereotyping because of the case. Now it's much broader and much more protection.
Right. No, and it will be interesting is that the law at issue only apply to employment, but there are dozens of other laws that say you can't discriminate against somebody based on sex that are going to be probably read the same way. There's no logical reason why you wouldn't. And so, you know, Title IX regulating institutions of higher education, Fair Housing Act, all kinds of other things. The movement has spent the last 25 years trying to get these protections enacted by Congress and could never quite do it. Now in one fell swoop, we've come a great ways toward much greater equality, not just from governmental discrimination, but from private sector discrimination, which is just enormous.
So would you say this is where we see the future of law in this space going? Do we see it being that I may interpret it on the basis of textualism, but I'm actually doing sort of textualism plus, being that I'm using textualism, but only if public opinion is sort of in my favor as well?
Well, I mean, you could say that. It's a little hard to know what's in the mind of a justice, but it is definitely true, I think, that Supreme Court practitioners don't like to ask the court to do things that they know will be viewed as illegitimate and unpopular among the American people. There's the old idea that the Supreme Court follows the election returns, and you know, there's certainly something to that. But if you ask about the future, what the future of litigation in the area of LGBT equality is going to be defensive now, because even Gorsuch's opinion notes that there are lots and lots of ways in which religious employers can argue that they should still have a right to discriminate because of their religious convictions, and that the law shouldn't be able to force them to give equal treatment to gay people or transgender people. And that sort of religious backlash has been going on now for a number of years, but it's getting more and more aggressive, more and more well organized. We saw the Masterpiece Cake Shop case, which kind of punted the issue. We have a case next year about whether Philadelphia can say to the Catholic Social Services agency that places foster care, children in foster care, that they have to be willing to place children in same-sex households, couples households. They said it's against our religion to do that. And I think the court's going to be pretty open to arguments that, well, we are going to protect the equality of LGBTQ people. We're going to try to accommodate that with protections for the right of religious the conservative people to continue to have zones in which they can follow their religion rather than following anti-discrimination norms. And where that line is going to end up being drawn is going to be complicated and murky. But an indication that the court is very solicitous of this kind of discrimination argument for religious people was the Hobby Lobby case a few years ago, where they said that the Hobby Lobby company has, because of its religious convictions, can refuse to give certain kinds of insurance coverage for birth control to its own employees, contrary to the Affordable Care Act. So that's going to be fought out inch by inch, World War I style, I think, for the next 10 years, where that line is between religious freedom and anti-discrimination equality norms for LGBTQ people. And it's happening right now, and it's going to keep happening, because it's pretty much the last move that our opponents have for trying to oppose our equality, is to say, well, we want to have zones in this country where we can continue to follow our religion rather than your laws that prohibit discrimination.
All right, so we are right at 15 minutes remaining. Erin, did you want to now transition to questions from the audience? What are your thoughts?
I think that's a fantastic idea. So let me go ahead and just start with a question based off of one of the questions that was asked in the audience. So the question was, and sorry, I'm just scrolling right back up to it. Do you think that, well, I think you partially answered this. Do you think that Scalia was predicting the bus duck cases? Are there any other predictions that you're seeing coming from Scalia or from any other dissents that have occurred recently that would predict new cases or new lines of legal precedents?
Nothing really comes to mind. I think Scalia was back in Lawrence predicting Obergefell and said that once you take moral justifications out of the mix, the state really doesn't have much interest in differentiating between same-sex couples and different-sex couples. And he had enough faith in the logic of the law that he said one will lead to the other. And it proved to be extremely painful for the advocates of trying to prevent marriage equality to come up with a reason why they couldn't give marriage licenses to same-sex couples for the next 12 years. They kept trying to argue that. And so I think Scalia was right in that prediction. But I don't think justices tend to predict as often as Scalia did, and nothing comes to mind in terms of a future prediction of that kind.
All right, Erin, any other questions you have from the audience?
I do have a second question, looks like. Again, this is based off of one of the questions in the audience. So there's a number of these statutes that are still on the books, or they're still in the form of regulations that are still technically available. They're just not currently enforced because of the Supreme Court decision. Do you think that an important part of the actions or legal actions in the future will be to remove these old, outdated laws? Do you foresee a big action to try and clean up this work, or do you think that that's still sufficiently unpopular that it won't occur?
Well, we still have the homosexual conduct statute on the books in Texas. 2106 is still on our books. And there's an asterisk, then you follow the asterisk down and it says ruled unconstitutional by Lawrence versus Texas. And every legislative session, which is every 2 years, the State Bar of Texas and the LGBT section of the State Bar asks to recommend that the legislature remove this unconstitutional law, and they won't do it. So this is the role of politics. And so sometimes it's misleading, because people who go through the statute see that it's still there. And if they don't look at the statute of the little asterisk, then they think that it's still good law. But it's still on our books 17 years later. It's still there in Texas.
This is typical, actually. There have been a lot of laws that have stayed on the books for years that are unconstitutional. There's school segregation laws that still exist on in the codes of some states, things of that kind. And I think it's good practice to repeal them. But as Mitchell says, there are times in which some politicians like to avoid sending a message that they agree with the Supreme Court by going ahead with the repeal. They would rather simply not do it, or maybe they like to continue to assert their opposition to this particular Supreme Court decision by leaving the law on the books, even though it can't be enforced because it's been held void as unconstitutional.
So I want to just comment on the Lawrence versus Texas case. And this happens, I guess, Paul, you're familiar with this. At the end of the opinion, it just says it is so ordered. It's like, okay, they don't say, well, what needs to happen? So it took months for that mandate to come back to the Court of Appeals or the Supreme Court of Texas to do it. And when they finally acquitted John Lawrence and Tyrone Gardner, when you read the decision, it's kind of like it's not like they were doing this willingly. They say, well, I guess we have to do this because the Supreme Court ruled, and so we hereby acquit John Lawrence and Tyrone Gardner. But they did it begrudgingly, months. It took them months to do it. And, there's nothing at the end of the decision that says, you are hereby ordered to acquit them. It just says it is so ordered. And we were waiting and waiting and waiting for the Texas court to do something. So I just share that with you that happens sometimes.
But meanwhile, they got to be heroes, and they were the grand marshals of the Pride Parade in Houston and that sort of thing, along with you. It was a fun time. I found myself running off to fundraisers all over the country and getting awards of one sort or another, and ran into Tyrone and John once in a while at fundraisers. It was a remarkable time, even though waiting for the actual legal relief in the lower court sounds like it took a while.
That's true.
All right, I want to thank everyone in the audience for sticking with us. You've had a great audience, gentlemen. They have stuck with you the entire time. I'm always thrilled to see that. So before we close out, I want to give you both the option for any final comments you may have on anything you talked about today.
Well, let me first of all say thanks to Fastcase and Ken and Aaron and Joe, everybody who've done so much to organize this. It's been a real pleasure. Thank you for bringing me back together with my old partner in crime here, Mr. Katine. And thank you for remembering Lawrence versus Texas. I think it really was a foundation of all the stuff that we're very happy to see, Windsor, Obergefell, even Bostock in many ways. This is where the tide was turned in the movement from a time when we lost every case to we started winning every case. And so it's worth celebrating on June 26th. Turn it over to you, Mitchell.
On this date, 17 years later, when Lawrence versus Texas, it took, 4 or 5 years to go through. And before Lawrence versus Texas, we were talking about the case around the country at law schools and universities. And people would ask, why are you doing this? What's the purpose of all this? And I always said that one day I would have children, and that I want my children to live in a country where they can love who they want and be free from persecution, no matter who they're attracted to. And now that my children are high school graduates and going off to college, and I just feel like that, that dream has come true. And also, whenever somebody gets married, and I see that they're married out there, a little piece privately in my heart feels like we had a little role in that. And there's so much love and there's so much happiness. And Paul, you and I aren't going to be here forever, but I think Lawrence versus Texas will be around and help our country be a better place long after we're gone.
Yeah, it's good to think, isn't it? It's nice to know we did something.
Yep. And I really, I'm in private practice. Constitutional scholars like Paul Smith and the lawyers at Lambda Legal were a real privilege for me to interact with and work with. So, Paul, I want to thank you and all the other lawyers who helped us get where we are.
I wouldn't have turned down the opportunity for the world. It was a life-changing experience for me to be the person who got to do that.
Well, I personally want to thank you on behalf of the audience and on behalf of myself and Ken and everybody here at Fastcase as well. Specifically, I want to thank you for your work in the jurisprudence for this case. I want to thank you for representing the plaintiffs in Lawrence v. Texas. I want to thank you for doing the background work, for doing the work since then to make sure that the information about this case is accurate and to make sure that it's well known in the field, because this is such an important case, just from a human rights perspective, from a LGBTQ perspective, from a jurisprudence perspective. I have been thrilled to do the work on prepping for this day, and also thrilled to be a part of this. And forgive me for babbling, but this has been an awesome experience, and you guys have been wonderful advocates during this presentation as well.
Thank you very much.
All right, so our final closing announcements. There has been a recording made of today's session, and it will be available and be sent to all people who registered for today's session. Do allow us a little bit of time for it to render and be posted so that you can have access to it. Also, as a reminder, this presentation is not generally available for CLE credit. However, CLE credit is available in Texas. The code for today's session is 174090604. Again, that's 174090604. And if you had any trouble writing that down, if I said it too quickly, please feel free to email us at support, that's SUPPORT, @fastcase.com, and we'd be delighted to send it to you directly. Thank you so much, gentlemen. And Kenda, do you have anything at the end?
No, I just want to say, I want to mirror what Aaron said, the southern little gay boy inside me who's about to marry the man of his dreams is thrilled to have you, and it has been very impactful on me personally, and I assume I can speak for our audience at large as well on that note. Thank you so much.
Congratulations.
Thanks, everyone. And congratulations. Yes.
Thank you, gentlemen.
Take care, everyone.